Good evening, hello and welcome to the special broadcast. I'm Anusha Soni. A recent order by the Kerala High Court has once again sparked the debate around the need for a uniform civil code in this country. Specifically, when it comes to having a uniform age of marriage for everyone, irrespective of religion. Now, to marry off a child below 18 years of age is an offence under POCSO in this country. Child marriages are prohibited in this country, and individuals, anyone facilitating such marriages, is liable to be prosecuted. However, all these penal provisions are somehow put aside and they've somehow put under the question the moment it's about the marriage of underage Muslim girls. The reason? The Shariat practice of girls becoming eligible for marriage upon attaining puberty under Islamic law, a law that finds some degree of legal protection in this country. All thanks to the 1937 Shariat Application Act and certain judicial pronouncements that protect personal laws, sometimes at the cost of fundamental rights. But when it comes to a uniform age of marriage and setting a standard for all communities, arguably this is a matter outside the scope and precinct of personal law in this country, because it squarely falls under the teeth of certain criminal provisions designed to protect the child rights. While this is an argument before the Supreme Court, the matter is still pending the final word to come from the top court of the country. But in 21st century India, should a progressive, liberal democracy like ours permit the marriage of underage Muslim girls? Our top views. As far as the high courts in our country are concerned, there is no uniform view that has been expressed so far. Let's take you through some key opinions that have come in, differing opinions and views that have come in by various high courts of the country. Now, let's begin by what the various high courts have said. Kerala High Court recently says that marriages of minor Muslim girls are illegal because there's POCSO in this country, and that is the law that overrides. You had the Punjab and Haryana High Court uphold the Sharia practice and say that under the Sharia practice it's allowed, and that's something which is under challenge at the Supreme Court. Delhi High Court had also said that minor Muslim girls could marry at the age of 16, keeping the Islamic practices into mind. Moving on, Gujarat High Court had also said that Muslim girls above 15 could get married. So these are the different opinions, contradictory opinions that have come in, and of course, the Supreme Court will have to settle the matter. Let's now move forward and talk to you about which direction is it where this entire debate is going. Now, NCPCR has moved the Supreme Court against the Punjab and Haryana High Court judgment. They have said that there should be a standard, a uniform age of marriage, especially under the teeth of POCSO, which is a very stringent law. The petition is pending in the Supreme Court of India, and that's a matter that awaits final adjudication. The child rights body seeks uniform age of marriage, protecting child rights in this country, the bodily autonomy, especially of women. Supreme Court, as I said, will have to settle this debate, and this debate is also largely about to what extent can personal practices be protected, especially when they are directly violating your fundamental rights, outlawed by a statute that makes it criminal. As we begin this debate, at the outset, let me put out some questions that need final adjudication from the courts and in the public domain. Can Sharia practices survive the teeth of POCSO? This is not just about civil laws, this is about criminal laws in this country. Is there an artificial distinction that can be drawn based on religion? That if you're a Muslim girl, your rights are different, and if you're a girl from some other community, your child rights are different. Is that an artificial distinction we could have? And should there be a uniform age of marriage in this country, irrespective of the faith that you come from? That's a demand that has been made by the Supreme Court. And more importantly, should personal laws which are violative of child rights, not just fundamental rights, child rights, should they be set aside by the courts of our country? That's the larger debate that needs to happen. Now, taking all these questions to our panel of guests as well who are joining us on the broadcast, Mr. Kapil Sankla, who's a senior advocate, is joining us on the show. We also have Mr. Ratan Sharda, who's an RSS researcher and author. Ambar Zaidi, who's a social activist, and Yasmin Farooqi, who's the General Secretary of SDPI, is also joining us on the show. Kapil, let me come to you first and taking a view from you. The argument that POCSO or other provisions, other statutes that have been designed, they are criminal law, and any kind of personal law practices cannot survive the teeth of criminal laws in this country, because personal law largely is the civil law, which has been protected to a limited extent. To what extent is that argument tenable as the matter awaits a final word from the Supreme Court?
So let me say it like that the reason of POCSO Act coming into force was protection of minors, protection of minors from sexual exploitation, and so that their fundamental rights as to their body and their life is kept intact till they are of an age where they can decide for themselves. That's the purpose of POCSO law. Delhi High Court, you said that it goes against the grain of what Delhi High Court said, but Justice Indermeet Singh, Delhi High Court, in a bail matter had stated that the fundamental rights of a child has to also be looked into. More importantly, POCSO is aimed at protecting minors. That is one part of it. The second part of it is, what is customary law? Customary law is merely a law which has been accepted by a certain actors or community because it is acceptable in that community, and therefore a sleeve is carved out for them for as an acceptance which goes against what the established law is. Am I right?
Yeah.
However, POCSO is a special act, and in case of a conflict between general act, customary law and special act will always prevail. That is the established law. So under those circumstances where there is customary law or general law which is against or in contradiction to a special act, which in this case is POCSO Act, POCSO Act should prevail.
No,
so I do understand that there are certain judgments
I
of
understand that legal
Punjab
proposition, and I'm completely with you when you say that if it's a customary practice and you have a specific law which is written down, it's the statute which will survive. It's not the customary practice which is a vague practice or where some room has been carved. Then why is it that different high courts have taken different opinions? How should we understand that?
Well, so there are two aspects to it. It is normal for various high courts to have different opinions on the same facts. And when you have such, orders or judgments which are in contradiction to each other, they usually refer to the Honorable Supreme Court for decision. So in this case also the matter will go before the Honorable Supreme Court. That will carve out the law and establish it as far as this controversy is concerned. One. Secondly, you also have to accept the fact that those judgments have been passed by different judges on different facts.
Yeah,
So
not on the question of law.
Criminal law is not precedent. It's not on question of law. So it's a fact-based law precedent. So therefore, it requires adjudication, and the Honorable Supreme Court will decide it.
So we hope that this kind of different opinions or the question of law, as Mr. Kapil Sankla was also pointing out, which has not been settled, will be answered by the Supreme Court. Before I bring in Ambar Zaidi and Yasmin Farooqi, Mr. Ratan Sharda, I want to take in a word from you. Uniform age of marriage in this country, especially when it comes to the Islamic personal law, it's a huge gap that has not been addressed so far. I mean, forget the larger debate around the Uniform Civil Code. As we were earlier discussing, there are specific statutes that outlaw getting married under 18, especially for women and men equally, but especially for girl child and her interest to be protected. How do you see these kind of practices surviving in today's day and age, and sometimes even protected by the high courts?
See, first of all, we must look at the entire issue from the gender justice issue, child right issue rather than religious issue. If we look at it, a lot of confusion will go away. Because after all, why should a girl get married in a minor age when all the medical reports, all the medical studies tell us it's not a right age for the girls to get married? And it is against their own rights, their own body, their own health. That is very clear. Similarly, when the children's rights are abused, when they are not allowed to complete their wonderful childhood and forced into marriage against their wish, or even with their wish, they are not even aware what's happening. As high court judgments show that, a girl under 15 wants to marry without parents' consent, even that is allowed. So there is a lot of issues which are cloud because we start looking at through religious bias. we remove that, we think that we are a scientifically secular country, we are a democratic country, then we should look at the rights and look at the issues of men, women, children from the point of view of gender law, gender rights, and also their own power, their own health.
Let
If
me,
we do that,
yeah.
I do not understand why have high courts at such a high level. If it were district court, I can understand. I fail to understand why at high court level laws are interpreted in a different manner.
You know,
Is it a
Mr.
personal
Radan
judgment
Sharda,
at-
I agree with you that when it comes to issues like these, you should rather look at them from the point, view of gender justice or child rights. Those are the broad parameters that should be set. However, personal laws based on religion are a reality in this country, and that is why you have the high courts taking different opinion, a matter that awaits the final adjudication from the Supreme Court of India. I want to take this question to two, very reputed women who are with us on the broadcast, both from the community. Ambar Zaidi and Yasmin Farooqi, both are with us on the broadcast. Yasmin जी, पहले आपके पास आऊंगी. इस पूरे मुद्दे पर मैं आपसे जानना चाहूंगी आपकी क्या राय है. एक पूरा आर्ग्यूमेंट ये है कि अगर 18 साल की बच्ची, अगर वो मुसलमान नहीं है, किसी भी और धर्म से है, किसी भी और कम्युनिटी की है, उसकी शादी नहीं हो सकती, उसकी अलग किस्म के संवैधानिक अधिकार हैं जिनकी रक्षा की जा सकती है. तो क्यों हम 18 साल से कम उम्र की लड़कियों की शादी सिर्फ इसलिए होने दें क्योंकि वो मुसलमान धर्म से आती है? यास्मीन जी.
ऐसा कुछ भी नहीं है. देखिए मैं आपको बताऊं, अब लड़कियां सब जगह की पढ़ रही हैं और पढ़ाई के लिए एक सर्टेन एज चाहिए. तो मेरे ख्याल से हम देखिए, पहले दिल्ली हाई कोर्ट और हरियाणा कोर्ट इसके फेवर में दे चुका है, वहीं केरला हाई कोर्ट इसको फेवर नहीं कर रहा है. तो एक तो 3 हाई कोर्ट के जजमेंट अपनी जगह हैं कि उन लोगों की इज्जत करना हमारे लिए तो फर्ज है कि हमारे लिए तो तीनों वैल्यूएबल कोर्ट हैं. दूसरी बात यह है कि देखिए, जो बात कह रहे हैं 18 साल की उम्र में, तो ये तो तय है कि कोई भी, चाहे मुस्लिम हो चाहे गैर, मतलब ना मुस्लिम हो, कोई भी हो, आजकल कौन 18 साल से पहले कोई शादी करता है अपनी बच्ची की? मुझे ऐसा नहीं लगता, क्योंकि मेरे ख्याल से इस बहस में पढ़ने से पहले हम अगर एक एनालिसिस करें, कोई मजबूरी है, गरीबी है, या माँ बाप मर गए हैं, किसी और के पल्ले पड़ी हुई हैं, उन्हें जगहों पे मैं सोचती हूँ शायद 18 से पहले शादी हो जाती होगी. लेकिन जो पढ़े लिखे आज के मुस्लिम माँ बाप हैं या जो लोग समझदार हैं, मैं नहीं मानती कि वो लोग 18 से पहले बिना बच्ची को पढ़ाए हुए शादी कर दें.
यास्मीन जी, दो संदर्भ में आपसे मैं बात करूंगी. एक तो ये है कि जब हम कम्युनिटी में रिफॉर्म की बात करते हैं, देखिए, अगर मैं हिंदू धर्म की बात करूं तो कोई भी लड़की जिसकी 18 साल से कम उम्र में शादी करने की अगर कोशिश की जाएगी तो वो कानूनन अपराध है. पुलिस वहां पे एक्शन ले सकती है. अगर माँ बाप इस तरह की हरकत करते हैं तो माँ बाप के खिलाफ भी एक्शन लिया जा सकता है. इस्लामिक पर्सनल लॉ में प्रॉब्लम यह है कि एक कस्टमरी प्रैक्टिस के नाम पे इसको एक्सेप्ट किया गया है कम्युनिटी में. अब मैं आपसे ये समझना चाहती हूँ कि जब हम बदलाव या रिफॉर्म की बात करते हैं तो हम ये बोल के कि समस्या है ही नहीं उसको डिनाई तो नहीं कर सकते. 3 तलाक के समय भी ये बोला गया था कि 3 तलाक होता कहाँ है, होता ही नहीं है तो उसको अलग करने की क्या जरूरत है. चाइल्ड मैरिजेस हर धर्म में एक रियलिटी है इस देश में, और वो मुस्लिम समाज में भी दिक्कत है. वहां पर सबसे बड़ी दिक्कत यह है कि कहीं ना कहीं एक लीगल प्रोटेक्शन है तब भी जब एक लड़की अंडर एज होती है. क्या कम्युनिटी में अंदर से रिफॉर्म की कोई जगह है? क्या आपके बड़े बड़े नेता या जो धर्म के बहुत बड़े नेता होते हैं वो सामने आकर बोल सकते हैं कि अगर लड़की 18 साल से कम उम्र की होगी तो हम उसकी शादी नहीं करवाएंगे? क्योंकि कहीं ना कहीं उसका असर कम्युनिटी में किसी कानून से बहुत ज्यादा होगा. यास्मीन जी.
जी, मैं आपसे यही बात बार बार दोहराना चाह रही हूँ कि मुझे ऐसा नहीं लगता. ये कानून सबको पता है कि 18 से पहले शादी नहीं कर सकते, तो मुझे नहीं लगता कि कोई भी समझदार आदमी जो कानून जानता है, और ये तो मेरे आज बात सामने आई है कि साहब मुस्लिम लॉ में, मैं मानती हूँ, ये मुझे मालूम है कि 18 से पहले शादी, 15 के ऊपर शादी कहीं पे भी हो सकती है बच्ची की. मतलब 2 चीजें होती हैं, एक तो शादी या निकाह करना, पहली बात तो यह है. और दूसरी बात मैं आपको बताऊं कि जिस तरह के लड़की ना कर सकती है निकाह के टाइम पे, उससे पूछा जाता है कि तुम्हें इस आदमी से शादी करनी है या नहीं करनी है, वो अगर स्ट्रांग है तो वो मना कर सकती है. ये तो एक अपनी जगह अलग बात है. पर आप जिस पॉइंट पे बात कर रही हैं, क्या सिमिलर लॉ नहीं होना चाहिए, तो मेरे ख्याल से अगर कोई, आपको पता होगा कि कोई लड़का लड़की टीनेजर भागते हैं, चाहे वो मुसलमान हो चाहे हिंदू हो, तो वो माने तो उसी लॉ में जाते हैं ना कि वो अंडर 18 हैं, और अगर वो 18 से पहले भागे हुए हैं तो उन्हें उठा के लाया ही जाता है, उनका शादी तो नहीं कराई जाती, चाहे वो मुसलमान हो चाहे कोई भी हो।
पक्ष पे अलग अलग हाईकोर्ट की अलग अलग राय है कि जब टीनेज लोग हैं, लड़का मेजर है, लड़की माइनर है, 18 से कम की है और वो मुसलमान है, तो उसमें क्या राय होगी। बल्कि यही पूरा मसला है जिसके ऊपर अलग अलग हाईकोर्ट ने अलग अलग व्यू लिया है। आई एम कटिंग अक्रॉस टू Amber Zaidi. Amber Zaidi, this is a problem that exists within the Muslim personal law, and I say it out loud that it's legal to a great extent for a girl who's under 18 to get married if she's from the Muslim community. Is the community capable of addressing this problem? Is there a need for reform from within? I think a need that has existed, but is there capacity for it to be addressed?
Absolutely right, because the reform within the community is highly needed. But I would like to bring to your notice that last month only Haryana Punjab High Court gave a verdict on a case where a Muslim man went to the court for seeking his underage wife's custody. And in that case, the High Court ruled differently from what Kerala High Court, Karnataka High Court says ruled. So what I want to say is that as per the Shariat Application Act 1937, all questions related to marriage would be divided as per the Shariat. And after that POSCO Act came into existence in 2006. Yes. So it is questionable whether a personal law will be prevail or that POSCO. But
no, you're absolutely right in pointing out that legal conundrum that exists, Shariat Application Act 1937 and POXO. I'll take that question to Kapil as well. The point, Amber, I really want you to talk about is that whenever there is a reform which is brought in from outside by a judiciary or from the government of the day, when it comes to Muslim personal law, it is being said that the reform is being imposed. I want to address that issue, that if imposition is not the way.
Coming to that only, that see, we are living in a democracy and everybody is equal before the law. When we talk about the basic human right, whether like the act like this, why we are being we are being discriminated as per because of our different religion. You are a Hindu, I am Muslim. Why should we be being discriminated because of our different religious identity? We are equal before the law, and we should get equal rights under the Constitution of India. And absolutely, and this should be discussed and addressed by the larger group of our community. And
yes, Mr. Sankla, I'm coming to you. All right, Mr. Sankla, I want to come to you. And before you answer that, I also want you to talk about this. The Shariat Application Act 1937, which predates our constitutional history of independent India, continues to survive in today's day and age. How can that be reconciled with POXO? The Shariat Application Act is basically saying that all matters pertaining to personal laws like your marriage, inheritance in the Muslim community will be governed by the personal laws of the community. And that law in many ways stands in stark contrast to, say, an act like POXO. Mr. Sankla.
You're absolutely right, but may I just answer the lady first?
Sure.
It leaves a bad taste in my mouth when instead of arguments or coming up any valid points or statistics, all that somebody argues is that we are being targeted. Let me tell this lady that in Hindus there was polygamy that was allowed, it was subsequently banned. Sati was allowed, banned. Dowry pratha was allowed, banned. The latest was that Dalits could not be Pandits, or could not do Pandit and all of that in temples, again disallowed. Laws evolve, madam, and that is the purpose of laws. Customary laws also should evolve, looking at what are the customs now in congruences with what is applicable and what is the law today. You cannot stay under the garb of being a minority and therefore we are being targeted. I mean, that's such a shallow argument, madam. You see, your problem again is that, laws are not evolving, you're not bringing in the latest laws or latest technology. That is also your grouse. Now, when the laws are evolving on their own and courts are interpreting it, POXO wasn't applicable pre-independence, but it was made applicable now. And when it is realized that there is an incongruence, you talked about Delhi High Court. I spoke about Delhi High Court granting bail to a gentleman who got married to a 15-year-old girl. However, said that the aim of POXO is to protect the minor and therefore the court should look into it. And the government should look into it. So in today's date, when there is a disconnect or there is a contradiction, By law, even if this wasn't Muslim law, the special act would have prevailed over general law. But here where there is a direct controversy, and only because of the lady here who's shouting about minority rights, etc., this matter has to go to Supreme Court. If she is happy with the minors getting practically raped when she is also talking about marital rape happening?
To be the devil's advocate here, forget all these arguments made in the public domain that the community is being targeted or this is about minority rights. I agree with Mr. Ratan Shada what he said earlier, that we need to look at it from the gender perspective. We need to look at it from the point of view of, you know, child rights and protection to child rights for children from across communities and no discrimination based on that. But isn't this a matter keeping the host of patchy judgments and laws that exist that should be addressed by the Parliament of the day? If there is a case for uniform age of marriage in this country, shouldn't we have a law outlining it? Because we need that.
You see, the law is already there. Please understand this. There is a customary law, there is a special law. The settled proposition of law is that the special law will prevail upon general law and customary law. That is also settled law. But because there is an incongruence now of three different high courts talking about whether a marriage between a minor and a major is legal or valid or does it come under POCSO law, the matter is being referred to Supreme Court. It is done in time,
before I come to you, Mr. Ratan Shada, quick word from you. The argument that the minorities are being targeted or the Muslim personal law is being specially spoken about with some kind of ulterior motive. Address those criticisms.
See, this victimhood card must be stopped. After all, India was partitioned on the basis of religion. People who wanted to follow Sharia, they went to Pakistan. Those who believed in secular country, they lived here. Coming to some of the objections, see, triple talaq was also banned, and many people said it's an attack on Islam. But then people said, we will take care of itself, we will modify. They didn't modify 70 years, so law had to be brought in. Are they ready to modify laws which are against women? I don't know. And thirdly, when we talk of legal standing, do they allow legal stand? We are talking of. She said you can say no at the time of marriage, but in a conservative society, can a minor girl or a young girl really refuse marriage?
Yeah,
I very much doubt it. And finally, there is a law called Muta in Islam where you can have short-term marriage. In Hyderabad, there is a whole scandal of outsiders coming in having a short-term marriage. And did any mullah object to that? I don't think anybody objected to this. So this kind of laws have to be imposed. We cannot say it is on minor or major. And Mr. Sankla has pointed out, Hindus also gave up many such laws which are outdated. So if you are living in a modern society, you have to live as per modern society, not hark back to 7th century laws.
Okay.
They might be looked at that time, today they are outdated.
Amber, coming on this point, is there a certain sense of victimhood which is projected each time there is a talk of reform?
Absolutely right. Whenever you talk of any kind of reform, the people from the community says we are being targeted, our religion is being targeted. When we were working on triple talaq, this was the same. They were giving the same argument and reason that this is the part of our Shariat in Islam, nobody can touch it. And now when we are discussing the uniform age of girls, irrespective of religion, in recent judgment of Punjab Haryana, which I just mentioned, the High Court said a Muslim girl of 15 years, she can marry a man of her own choice.
एक बात और जो मैं आपसे चाहूंगी कि आप क्लैरिफाई करें, because you come from the community, you know the community from within. यास्मीन जी ने ये भी कहा कि आजकल ऐसे कौन ही लोग होंगे जो 18 साल से कम उम्र की लड़की की शादी करते होंगे. अगर माँ बाप पढ़े लिखे हैं तो ऐसा होता ही नहीं है. Is this problem non-existent within the community? क्या ऐसी कोई दिक्कत है ही नहीं?
It is very much existing, because just because I think I'm living in a bubble that I don't want to accept the reality. I work with the people and especially the Muslim women for years and years, and I know the reality. Just on this Saturday, I got a call from Assam. A Muslim girl, she was aged 16 or 15. She's pregnant, 5 months pregnant, and she's seeking for divorce because her husband and his family, they are torturing her and she wants to terminate the pregnancy and she wants a divorce. So these such cases are so apparent, and we are just seeing, I'm getting such cases every now and then.
यास्मीन जी, कहीं ना कहीं समस्या का सामना करने की बजाय एक सेंस ऑफ डिनायल रहता है कम्युनिटी में, एक ये आर्गुमेंट है।
We have to accept the problem.
एब्सोल्युटली। यास्मीन जी, ये सवाल मैं आपसे पूछना चाहूंगी। मुझे याद है जब 3 तलाक का पूरा मसला सुप्रीम कोर्ट में चल रहा था, तो ऑल इंडिया मुस्लिम पर्सनल लॉ बोर्ड ने एफिडेविट पर कहा था कि अगर 3 तलाक चला जाएगा तो बहुत सारे मुसलमान मर्द जो है वो they'll end up killing their wives, क्योंकि उनको तलाक मिलने में बहुत समय लग जाएगा, और उसको रोकने के लिए हमें 3 तलाक को रखना चाहिए मुस्लिम प्रैक्टिसेस में। तो इस तरह के रिग्रेसिव आर्ग्यूमेंट्स कम्युनिटी से आते रहे हैं, और अभी भी आप जो बात कर रहे हैं कि कम्युनिटी में तो ऐसी कोई प्रॉब्लम ही नहीं है, ऐसा तो अब होता ही नहीं है, और अगर ऐसा नहीं होता तो क्या एक कानून लाना चाहिए जिसमें चाहे लड़की मुसलमान हो या हिंदू हो या किसी और धर्म की हो, शादी की उम्र एक ही होनी चाहिए? यास्मीन जी,
देखिए, मुझे नहीं पता कि मुस्लिम पर्सनल लॉ बोर्ड, मुझे नहीं पता मुस्लिम पर्सनल लॉ बोर्ड ने क्या बोला था। मैं एक अपनी पर्सनल राय रखती हूँ और मेरा ग्रास रूट लेवल का काम है। देखिए, जैसा भी कहा गया कि आसाम में, या मैंने आपको क्या क्या का बेस प्रॉब्लम है गरीबी है, या आप ये मान लीजिए अगर ये आसाम की बात कर रही हैं तो वहां से ढेरों लड़कियां 15-15 साल की कमाने के लिए आती हैं, तो फिर आप उसको क्या बोलोगे? जो घरों में लोग कमाने के लिए 16 साल की 17 साल की रख लेते हैं, फिर वो भी एक कानून बना दीजिए। वो किस में?
यास्मीन जी, उसका कानून तो है ऑलरेडी, उसका कानून तो ऑलरेडी है, वो लेबर लॉज में आता है, वो चाइल्ड लॉज में आता है। नहीं,
बोलने दीजिए।
यास्मीन जी, आप बोलिए, मैं आपसे सिर्फ इतना कह रही हूँ।
वो बोली थी।
अच्छा, बोलिए यास्मीन जी, अपनी बात पूरी करिए।
हाँ, बोलिए, मैं आपका जवाब दे रही हूँ। जी, मैं आपका जवाब दे रही हूँ कि मेरा आपको बार बार यही कहना है कि देखिए, हम किसी भी चीज पे 2 हाई कोर्ट कुछ बोल रहे हैं, एक है तो हम बहुत अच्छा जवाब उन्होंने दिया है कि सुप्रीम कोर्ट तय कर लेगा। देन दूसरी बात मैं आपको एक क्लियर बता रही हूँ। आपको क्या लगता है आजकल के माहौल में, जो बातें मुझे नहीं करनी है, लड़का लड़की कितनी जल्दी बड़े हो जाते हैं, बहुत जल्दी। जो आपके फोन ये वो दुनिया भर का जो चल रहा है, बहुत जल्दी बड़े हो जाते हैं, और उस बड़े होने का खमियाजा पेरेंट्स को भुगतना पड़ता है, क्योंकि इतनी समझ तो होती नहीं है। तो कहीं मजबूरी भी लोगों की हो जाती है कि वो इस तरह की शादियां कर देते हैं। लेकिन एक मैं वही पॉइंट पे फिर आऊंगी कि हम जाहिलों की बात ना करके एक पढ़े लिखे उस पर एनालिसिस कर ले, अपन डेटा कलेक्ट कर ले कि कितने लोगों ने 15 साल की उम्र में अपनी बच्चियों की शादी कर दी है।
तो यास्मीन जी, अगर एक कानून लाया जाएगा जिस कानून के तहत मुस्लिम लड़कियों की 18 साल से कम उम्र में शादी को इलीगल बना दिया जाए, तो क्या कम्युनिटी उस तरह के फैसले का स्वागत करेगी? मेरा आपसे सीधा सवाल है।
क्यों नहीं करेगी? क्योंकि अभी भी कर रहे हैं ना, जबकि और आप ये बात कह रही हैं टीवी पे बैठ के कि लोगों को, शायद आपको ये मालूम नहीं कि मुसलमानों को ये पता ही नहीं है इंटरनली कि 18 साल से पहले शादी कर देंगे हम तो हमारे रिलीजन में आ जाएगी। पूरी बात सुन लीजिए, पूरी बात सुन लीजिए।
बोल लीजिए, आप अपनी बात पूरी कर लीजिए, मेरे पास समय कम है, मैं दूसरों का भी रिएक्शन लेना चाहूंगी। यास्मीन जी, बात पूरी करिए।
पर्सनल मैं यही आपको कहना चाह रही हूँ कि जो लोग आम हैं उन्हें यही पता है कि 18 साल की उम्र में ही शादी करना चाहिए, उससे पहले नहीं करना चाहिए।
Mr. Ratan Sharda, somewhere I sense the same kind of defense which was earlier put for triple talaq, that the problem does not exist. You're making a mountain out of a molehill, and this reform can happen. We are going to welcome it, but somewhere not addressing the gravity of the problem.
Are you asking me?
Yes, Mr. Sharda.
See, first of all, when she says that this is the problem with the jahils, not with the पढ़ा लिखा community, पर आप ही लोग कहते हैं कि मुसलमानों में अधिक से अधिक कम्युनिटी अनपढ़ है, अधिक से अधिक कम्युनिटी जाहिल है। मैं जाहिल का वो वर्ड नहीं कहना चाहता हूँ, मतलब जो आप समझ रहे हैं, लेकिन जिसके पास रहने खाने पीने का इंतजाम नहीं है, या जो गरीब है, इस तरह के लोगों को अगर कानून की तो उनको जरूरत है ना। अगर आप एक्सेप्ट करते हैं कि मेजोरिटी जो है वो गरीब अनपढ़ है, तो उनके लिए आवश्यक है, वही लड़कियों की शादी करते हैं। और जब आप कहती हैं कि हम ये स्वीकार करेंगे, तो फिर आप क्यों कहते हैं कि मुस्लिम पर्सनल लॉ पे अटैक हो रहा है? आप एक बात है ना, अगर आपको क्लियर कट लग रहा है कि ये बात जो है ये लड़कियों के फेवर में है, और अगर गरीबी की समस्या है तो पर्सनल लॉ तो सॉल्व नहीं होगी। अगर आप कह रही हैं कि पर्सनल लॉ
and I want to go back to the original argument that we made in the beginning of the show, that this is about child rights, this is about protection of child rights, irrespective of religion. There are various facets of Uniform Civil Code that we can debate, but when it comes to having a uniform age of marriage and protecting child rights in this country, I think the answer is only one. We need a law or some clarity to come in from the Supreme Court of India. I thank all my panelists. With that, it's a wrap from my side.